But please, I urge you to be flexible on the issue of time, particularly 5 minutes. My Lord, no council enjoys making an application for refusal of justice. It's a very weighty one. So please, allow us a little bit more flexibility.
Dr. Kamuna has submitted that he needs unlimited time, meaning that he can argue this case even until tomorrow. Mr. Mwite, how much time do you require for yourself?
I would say for those supporting at least 10 to 15 minutes. It's just relaxation that I'm asking for, so that the issues are wholly articulated.
My Lord, may I suggest that we stick to the time you have allocated us, and you have the discretion to allow anybody, including my learned senior, the Honorable PK.
That we just say that officially so that I don't feel pressure. I have 30 minutes. This is the kind of case, my Lord, that if you do inevitably, this case can somehow happen. I don't want anybody to accuse me. I did not argue this or the other when I.
Can you permit me to say something? What? This is our first impeachment case since we became impeachment cases. I mixed up with all those things like law, politics, security of the country, and etc. My very humble submission is so far as possible, let people say what they want to say. It's a healing process. And coming up with 5 minutes, 10 minutes, 7 minutes, my Lord, it does damage not only to ourselves, but the entire nation. It is a nation we are concerned about, all of us. When chips are down, the number just advocates take different positions when you have a matter before the court. But when it comes to impeachment cases, we are all concerned about the safety of the states, to save the states. Let people say what they want to say. They should not be pushing it. That's my view. And may I say to you most respectfully, I am coming to this matter on behalf of the Security Syria. We stand for the rule of law, the supremacy, and for preservation of the state of Kenya. Let people say what they want to say. Let us not come up with 5 minutes, 10 minutes, or 20 minutes and so on.
My Lords, Your Ladyship, I appreciate the matter before this honorable court is the recusal of the judges. But please, I urge you to be a little bit more flexible.
Time whenever it became necessary. So with those submissions in mind, we'll give you the time allocations which we have given, but with the latitude to grant more should it be necessary.
I was going to request that because we are prosecuting this application, that we just say that to accuse me, I did not argue this or the other when I had an opportunity. 30 minutes will not bring levels down. It is only 15 minutes to enable me to do the job, not for myself.
Yes, my Lord, here we go again. Here we go again, my Lord.
Let me speak. This is a court of law. I respect you very much, counsel, senior counsel, and all the counsel here. But please let us appreciate that this is a court of law. And when directions are made, please let's respect those directions. I'm making this direction. We have allocated time. Should it become necessary for one party to ask for more time, we will consider that. Thank you.
24. It is supported by an affidavit that has been sworn by this affidavit has been sworn by the Honorable David Muni Madenge. It is further supported by a supplementary affidavit that is 21st, a supplemented affidavit of 24th of October 2024 by the Honorable David Mahendo. Now, in addition to that, we have filed a bundle of authorities which I believe that they have been furnished to the court. My Lord, looking at my watch, it is 3 p.m. I am certainly going to require some additional time, but let me start and see how best we can manage the time that has been allocated. My Lord, in a ruling that you delivered yesterday, you made a significant point that this is a matter of extreme public importance that deals with the most weighty issue that can be conducted, both with regard to the office that it relates to and to the issue of political succession. My Lord, the issue of political succession countrywide is an existential issue of the state. Existential issue of the state in the sense that this is an issue that when you read Professor Namwebe, Ben Nabweze, and when you read all these cases from Pakistan, they are the most weighty constitutional issues that can appear before any group of judges. And my Lord, for purposes of this country, we are saying that for the 2010 Constitution, the matter before you, and that is why has informed the filing of this application, is one that is an existential issue for purposes of the 2010 Constitution. Your Lordships, I say
Your
that...
Honor, sorry for interruption. You have been muted. I am unable to follow proceedings. Okay. Now it's okay.
Yes, my Lord. So I was submitting and saying that it is an existential issue, the 2010 Constitution. We used to have Section 30 of the Constitution, in which Parliament meant the President and the Legislature. My Lord, those positions changed. The change of those positions, which is the submission that we are making, the impeachment proceedings would have the consequences, if it goes the way in which it has gone, of effectively and Section 30 of the former constitutions. Now, the second issue that I need to emphasize on the existential issues of the Constitution is this. My Lord, from the standpoint of the constitutions, and to safeguard constitutionalism, there is these issues that is called security of tenure that certain offices enjoys, particularly with regard to the questions of removal. My Lord, the two offices that enjoys the greatest tenure are the office of the President and the office of the Deputy President. My Lord, why is that the case? Because they are legally protected that to remove a president or a deputy president, you need impeachment. They are also secured by the electoral process, that those two people, to get to those offices, they must be voted into those offices by the people. But the significance of this is this. Every other holder of the offices, from constitutional office holders to judges and everybody else, doesn't enjoy political tenure. It is only legal protection for those particular offices. So that, my Lord, the point is this, that the true weight of this matter is this. If it were to turn out that an office that enjoys the greatest protection, like the office of the Deputy President, can be called, the removal can happen as we are alleging it happened in this case. My Lord, the whole scheme of constitutional tenure and protection that is necessary to protect our democracy would effectively be null and void. This would mean if you have numbers, you do not like the speaker of the day, you can get him out. Numbers in a democracy, and that is why you write the constitutions, numbers must be controlled by law. If we reach a position where numbers cease to be controlled by the law, my lord, that would effectively have negated all the constitutional gains that this country has made. My lord, having made that point of the nature of the issues that we are dealing with, let me come to the issues before you. My lord, the petitioners, or in those cases, in those affidavits, in the applications, are saying a fairly simple issue. They are saying that as a result of events that occurred in Kirinyaga, that are partly the subject of yesterday's decision that was made, and as a result of other matters that is the subject of the supplementary affidavit, the petitioners feel, and the petitioners are of a strong opinion, that a case of this magnitude is not the kind of case that should be decided by a bench in which they do not enjoy full confidence in. My lord, the basis of that, since this is highlighting, would be four. My lord, on the first issue is that the petitioners, and in the applications that they did and is a subject of overruling, they pointed out certain issues that brought into question the issues of the transparency, the proper accountability for purposes of the handling of that particular file. The affidavit is there. And then, according to the petitioner, that brought into them some doubts, the manner in which the handling was done, as to the impartiality of this particular bench. The petitioners goes on to issues number 2. They said that whereas they put in an affidavit setting out the reasons why there was a problem in the manner in which those issues were done, the respondents did not respond to challenge those particular set of facts. But my lords, the petitioners are saying that now that the respondents did not challenge their set of facts, the contrary issue that happened is this, that in the ruling that was read yesterday, we got a copy 30 minutes ago, there was a section that was called Other Issues. In the section that was called Other Issues, the petitioners are saying that this court answered factual and evidential issues that relates to that application. And the consequences of that is that although they had been agreed, to them that would amount to this court entering the arena of conflict between the parties, the petitioners and the respondents. And my lord, the old principle applies that a judge, one cannot be a judge of his own cause, and in any matter that they are dealing with, it should be a matter that they are absolutely neutral as far as the facts and the evidence are concerned. My lord, in our African societies, I've talked to my parents, I talked to Mr. Ogata, he said his community had the same set of issues. According to my community that I came from, in any those cases that used to be done traditionally, the first thing that would arise was this, and Article 159 says we respect our customs. It was who will be able to determine this case. Are all the parties satisfied with this group of wazes that will be deciding the case? If either of the parties
My community does not do that.
I don't know about yours. I say mine and Okada. Mine is...
Okada is mine.
I don't know. Okada will talk for himself. But let me have some peace. I think he wants to destroy my train of thought. So that the point I was saying, I can be happy. Okada can defend himself what he told me. But my lord, I'm saying, at least for my community, that issue would arise. Does any of you have a problem with any of these wazes who will decide the issue? My lord, if the issue arose that a party says, we don't want that mzee to be there, or that other one, invariably, and this is communal justice, that person would pull out and get a mzee, another mzee, that everybody feels comfortable with. So that, my Lord, and I've appeared with you, I respect all of you absolutely. The petitioners are saying the circumstances of this matter is that we are unable to enjoy that confidence. My Lord, when the petitioners were speaking about what they said they feel, like is a three-judge bench, one in which they expect fair and square justice. That was a terminology in the case of Gerongori that we have attached on our submissions. That from the word go, a party appearing before the judges should be able to feel that we have a reasonable chances of success between those judges, but more importantly, that none of the judges is connected to the cause, one, to the cause, or to the individual in which you are in dispute with. My Lord, why is that important? That, my Lord, is important because since Saturday of this week, in fact up to yesterday, the petitioner says they have been treated to a situation, and a lot of those information people have sent it to my phones because they have seen me on television. Where we have such a scenario that repeatedly they keep saying we are going to have what is it called? We are going to have a swearing in as soon as these three judges give those particular orders. But that cannot create confidence because assuming it is not this case, every party, and we have very many cases here, if somebody you are drinking in a bar says, no, you are going to lose that case before the persons we are appearing before. That, my Lord, is a party. Parties are not lawyers, are not supposed to be sophisticated. That party will be left certainly with a huge, huge problem as to whether actual justice is possible. And it might actually be, my Lord, that whenever else is dealt, the petitioners will win this case. As we expect, we shall win if the petition is heard. My Lord, if that is the case, and that may actually be the case before you, but my Lord, the scenario that is banned and that is prevented by the law is a scenario where the parties lose. Because they will say, well, you have Ahmed Nasir told us, Oscar Suki told us, Kanket told us, and all these individuals who are saying it was called drama. We are here for entertainment. My Lord, if judges are supposed to be treated to entertainment, and those judges are supposed to stop that entertainment, my Lord, there is a problem on the face of it. There is a notice of appeal that we have filed, and it is part of the supplementary affidavit. In this notice of appeal, Your Lordship, we have pointed the issue, and we have said one of the other issues of concern is that the judgment of this court that dealt with these other issues, that judgment, the contents of that, amounted to preempting and answering the application that I'm arguing before the court. Because those issues we are submitting did not come from the respondents, but these applications having been filed, we are arguing these applications. After, in a previous ruling of yesterday, we have effectively been responded by the court itself. The petitioner says that they are absolutely uncomfortable with that, and they cannot be able to say that if we have reached a situation whereby judges are answering our case in advance, it is absolutely bad and beyond repair. But Lord, the second last issue that I want to say is this. The issues, my Lord, is, and we expressed that concern yesterday, we were not sure whether we would even file a notice of appeal as counsel. But you are told you cannot file this one because it is the issue, as far as we are concerned, we were not treated fairly. We were accused, we are playing to the gallery, as a result of the accusations and indictment that we are playing to the gallery. What effectively ended up being glossed over is the question of, is a question of our own submissions. And my Lord, the basis, and therefore the accusation, and we are saying we were not treated in a temperate and judicious manner. The petitioners and their advocates. Then, my Lord, we go to the deciding for purposes of yesterday, the core issue. My Lord, the core issue in our petitions, a number of them when it comes, would be the question, does the IEBC have the power to have authorized the president to say that he did? I'm saying it is in our petition. I'm saying one of the issues that will be coming in for determination.
My lords, I think it is important to just help my learned friend. We are not arguing the substantive application. It's a recusal. Let him stick to the issues.
Let him hear the issue and the answers.
But just do the right thing.
My lord, the point I was making is this. One of the questions, I want to tie it with 165. And the question is this. The question that would be arising is whether the IEBC without commissioners could have declared Honorable Kindiki to be suitable for this nomination in the letter they did to the president. My lord, that particular issue is significant because the petitioners are saying that this court, having effectively read Article 165(4) in a manner that amounts to amendment of Article 165(4), they perceive the real danger that when a more important question arises, the same logic would be applied against them. And they are saying, this being a very serious legal issues, the bench cannot be said that for purposes of the issues actually in contention, that the people can be oblivious of such an issue. I need like 2 or 3 minutes. My lord, having said that, therefore, it is our submissions. And as our Honorable has said, nobody extracts any joy to raise this kind of an application because judges are legal politics. But my lord, the point that we also want to add for purposes of this application, and this is contained, I believe, in the affidavit of my clients, is of course to point out to the issue. But the Honorable, the Deputy President, regarding Gachagua, by a letter dated 23rd of October 2024, did file a complaint against all your lordships, and this complaint was acknowledged by the Judicial Service Commission that it has been received. Then there is the issue that required disclosure. According to the petitioners, I wasn't even aware of this, I saw it today. According to the petitioners, is that there is a very close relationship between one of your lordships, the Honorable Judge Murima, and the Speaker of the National Assembly, who is the Speaker of the Senate, who is a member of here. That close relationship, according to the petitioners, is one that ought to have been disclosed so that parties could be able to make up their mind that are you comfortable? And we do that every day. I've actually not proceeded in a number of matters for some of the judges who are my classmates saying, keep your this, you are close to a friends, are you comfortable? That question ought to have been raised. That issue was not raised, and as a result of that issues not having been raised, and now having come to public notice, the petitioners are of the view that it would not be proper to be able to proceed in this matter. My Lord, in conclusion, what I would
My Lord,
like
before my learned friend concludes, I want you to be added another minute. Could he please, to assist us to respond, set out the nature of that relationship and where it is expounded in the affidavit?
Well, my Lord, I thought that can actually come during the response, as I say.
No. The duty, the burden of establishing facts is on the person pleading the facts. So we want to know that relationship so that we can respond to it.
Yes, my Lord. I have no problem whatsoever. There is a written affidavit. My Lord, in paragraph 6 of the supplementary affidavit, it reads as follows. Whereas I was not aware about the relationship between the Honorable Justice Murima, who is among the 3 judges handling this matter, and the 4th respondent, that is Hingi, it has been brought to my attention that the Honorable Judge and the 4th respondent, Speaker of the Senate, are very close friends as demonstrated as we are under. one, the respondent attended the wedding ceremony of the judge and he took a photograph with him. Number two, in a post on social media, he indicated. I thought I should finish.
May I say something? May I say something?
Yes.
The position that my friend has taken, in my humble submission, was more support to this. We are not here to destroy professions. Disclosing some of the details may not be the right thing to do. I think one should make a reference in a tactical manner, which the lordship will be able to appreciate of what is going on. I would respectfully say to you that this is an area where we have also to protect the judiciary, the judges, the magistrates, the judicial officers. I'm not very sure that we should have an in-depth account of what really what is contained.
Thank you, Dr. Kamino.
Let me explain that, my lord. There is a new affidavit that has just come online that contains some of these allegations. It wasn't there before, and that's why we sought. Now, you may proceed.
My lord, I think I agree with Dr. Kamino that unless, because as I say, I am not the source of any of this information or something that came to my knowledge, that I was sticking to what my learned colleague is talking about, unless there is insistence by my learned colleagues. My lord, I do not see the value of that insistence as for Dr. Kamino's position. It is stated in the affidavit. I will not say anything more on that. The respondents can say we can have a rejoinder when the issue arises. My lord, and the problem with these issues of somebody not continuing what they are saying is that you keep forgetting the last point. The last point, my lord, I think that I was making is this. That at the heart of an application for recusal, the authority speaks themselves, the one we have cited, I may not have time to go through them, is these issues that are considered very important. Number one would be whether, on the basis of the accusation and apprehensions set out, would one party feel that their rights to fair trial before an independent, impartial, and fair tribunal be upheld? The petitioners on that score are saying their right under Article 50 to fair hearing, which is absolute, would not be possible in the circumstances of this case. Number two, there is a question of the right to protection of law under our Constitution. That right to protection of law requires that for it to be protected, there must not be any doubt that that protections would be availed if it is deserved in accordance with the law. The petitioners again say they have reasons to believe, as a result of all matters taken into account, that their rights under Article 27 will stand. Issue, it could not really have been final, but I have to finish. Now, the final issue that is critically important for this issue is the old notion, the old principle that justice must not only be done, but must actually be seen to be done. In the circumstances of this case, it is our submission that apart from the real issues that the petitioners had, whether perceptions, whether substantial issues, the petitioners are saying that, your lordships, they are unable to say that at the start of these proceedings, we are confident that these judges are capable of upholding our constitutional rights and to uphold justice equally between us. Lord, we are most observed. Thank you for letting me conclude substantially on what we set out to do. We are not obliged.
Thank you.
My Lord, before the next speaker goes on, I think there is something we are doing and it is not fair to the court. Because my learned friend was challenged by Professor Mugay to tell you what is the specific thing. Then they take the posture, assisted by the senior, that we don't want to go there. You cannot eat your cake. The reason they don't want to go there, my Lord, is because it is frivolous. Now, the misfortune we have is this. The world is watching these proceedings. They said we don't want to go there. And the typical person watching things, there is something very serious about the integrity of the court that they have raised. When as a matter of fact, going by the list yet began is that the judge attended the wedding. The judge went to a restaurant. In one of the applications, they said the judge went to some law school. Clearly, we are being unfair to the court. We want to paint a picture, hiding at that we don't want to go there, so that the world will be left with the impression that there is something terrible about it. My Lord, I think it is Lord Cromwell who said, if you want to paint a picture of me, don't embellish it. Say it once and all. If they have any allegations now that we are broadcasting these proceedings to the world, if they have an allegation of any impropriety against any judge, they can't make the claim. For the gallery, then say, we don't want to go there.
There's something wrong somewhere. What's up? I am offended. I'm going to know.
You can't.
Is there something going on that's wrong?
That is the gallery. No, this one is the gallery. There must be something wrong with the gallery. So I think it is something technical. If
May I address Madam?
just a minute, please. No, just a minute, please, Dr. Ari. If you are using a gadget and your gadget could be causing this noise, please just set it properly.
May I make a comment, Madam? May I remind Madam friend very, very respectfully. It's our duty to protect
They applied to
They are not protecting the court. They are telling the whole world that this court is improper, it has improper motives. They can't have it both ways.
May I say what I want to say?
My lord, when they apply for recusal, they go the whole hog. You don't apply for recusal of judges.
I think the proper way, Dr. Kaminwa, let parties submit according to the directions which we gave. And again, there is an application supported by affidavit. There are averments in those affidavits, and because some of those averments actually touch on us, but we cannot defend ourselves, we would be satisfied if you read them even verbatim, so that the world knows that these are your complaints against the bench.
Madam, may I say something?
No.
As your lordship is aware, at times when we're in a court, we open the court.
Okay, Dr. Kabuna, please say what you want to say.
You will say to a judge or judges that there will be information that I would like to show clearly that it cannot be a and we go to the chamber so that I can disclose that. I'm not asking for the go to the chamber. Also, I will say, as lawyers or as advocates, we are also under duty to protect the judicial system and to protect the institution.
I think that is okay. That is okay. I think one way of protecting judicial officers is by disclosing in open court like this what is there.
By being blunt.
Exactly.
Be blunt.
I'm not with you with respect.
You brought it yourself.
My Lord, next time, I hope also, don't have to say it must be within 15 minutes, which is what we were trying, then accuse you of not reading everything. Because I have not actually read everything. There are other issues I could also have read. But my lord, let me read this. My lord, hearty congratulations to my long-time friend. That was underlined by Beth. And the source is Right Honorable Amason Jefakingi, EGH. The petitioners said the issue, and that is the issue that I picked during my submission, that there is a long-term friendship between the judge and the party. That long-term friendship ought to have been disclosed. I say that. Then it goes on to say, on the occasion of the renewal of your marriage vows with your beloved wife, this is now there, evidence that they are giving. You are a true testimony to the belief that spouses resolve to stick with each other through thick and thin, great things can happen. I wish the two of you the very best in this long journey and pray that God continues to bless this union and review with wisdom and the patience that comes with marriage and family life. Hongera kakangu. And below there is the photograph where a gift is being given by the Honorable Mr. Kingi, Senator, to the couple of Judge Rima and I believe his spouse. That is the annexure that was put by the petitioners in proof of the fact that there is a close relationship, a close friendship that under the law ought to have been disclosed, given that Kingi is a very important party for purposes of the case against the Senate that he botched everything and has come here to defend those impeachment proceedings. I believe my job is done, and because that is all that it says, and that is the affidavit of the petitioners. Unless they need me to read something else, no, I can sit down.
The second applicant.
May it please you, my lords, my lady.
Or we take it in another file or the same file?
Yes, my lady.
It's not in the same file. Yes.
I am in 509, where we have the application.
509 is in cohort 1. Eh?
Yes, cohort 1.
Give us 5.
Your Lordship, with profound respect, permit me, Your Lordship, to indicate that we are arguing the application dated the 22nd of October, with a further affidavit, Your Lordship, having been filed this afternoon through the court's email. Your Lordship, from the onset, it's with heavy heart, Your Lordship, that we have moved you through these mechanisms. And that, Your Lordship, my submissions are the submissions of my client, and that I'm just a vessel for putting across my client's case. Your Lordship, there is a notice of motion that seeks the recusal of this bench. The same, Your Lordship, is supported with an affidavit and an annexure. Equally, the further affidavit is supported by 2 annexures. In my submissions, Your Lordship, I will heavily rely on the facts contained therein.
What's the date of your application?
The 22nd of October, Your Lordships, my lady. I'll begin by indicating and relying on the Judicial Service Code of Conduct and Ethics 2020, and I draw the attention of the court to Regulation 47. Regulation 47, Your Lordship, states that a judicial officer may recuse himself or herself in any proceedings in which his or her impartiality might reasonably be questioned, where the judicial part of the proceedings, B, was or is a material witness in the matter in controversy, C, has personal knowledge of disputed evidentiary facts concerning the proceedings, D, has actual bias or prejudice concerning a party, E, has personal interest or is in relationship with a person who has a personal interest in the F, has previously acted as counsel. A recusal by a judicial officer shall be based on specific grounds to be recorded in writing as part of the proceedings. Your Lordship, it is my client's the bench should recuse itself on the ground contained therein. Permit me to begin by indicating that yesterday when the court was delivering its ruling, it indicated actual bias on the part of the parties before you, Your Lordship. The petitioners were condemned in a wholesale, in disparaging language coming from the bench, a language that indicated prejudice or bias on the part of the petitioners. It was indicated by the bench, Your Lordship, that despite the heavy submissions, the authorities that we quoted, we were not addressing the bench, but addressing the gallery. It is so prejudiced, Your Lordship, that such perception on the part of the petitioners culminated into the court not even taking note of most crucial issues that we had submitted on. For example, despite the appeal that is now being launched, the court failed to take into notice of the question of delegated authority. It is a considered submission, Your Lordship, that had it not been for the bias and the prejudice that the court has on the part of the petitioners, such would not have escaped the mind of the court. Your Lordship, further, the court made further remarks that they take great exceptions with the remarks of the petitioners. When the court indicates that they take great exceptions with the remarks of the petitioners, it's a prima facie indication that the court has descended into the arena of dispute, and that the court therefore becomes or takes a defensive approach in the manner in which the prosecution of the case is being conducted. Your Lordship, a judge must at all particular time be a solemn person, slow to anger, and of good temperaments. Your Lordship, the statement indicates that the court has taken a position as against the respondents, the petitioners. And the position is prejudicial to the petitioners and erodes their confidence to continue appearing and making submissions before this court. It was the observation of this honorable court, Your Lordships, that my client indicates that the court made further findings that the petitioners were not pursuing the urgency of their applications. What a reasonable man, a bystander, a fair-minded person, listening to these statements, internalizing them, will come to a conclusion that the court has taken a hard position on or against the petitioners. The test of a fair-minded person, Your Lordship.
My Lord, we really to intervene, but my colleague, if he is added time for it, it's okay. But let him tell you how, yes, the ruling you issued would be a basis for an application that was filed long before that ruling.
Your Lordship, if he may be patient, he'll have his chance to bite the cherry and respond in that manner he so thinks that he should. Your Lordship, the application has also indicated that Justice E. Ogola is closely associated with his spouse, who serves in the Water Kenya Towers Agency. The averments of our clients, Your Lordship, is that this is a matter that ought to have been disclosed at the inception of the proceedings.
Let me get you right. You mean the judge is closely associated with the wife?
That is not my statement.
Yes, what is it that you said? Repeat for the record.
May I repeat for the record? So that the court may not again misquote me.
Proceed.
Your Lordship, the spouse of His Lordship, one Florence Oluoch Auma.
You point to that issue?
Yes?
There's a disposition to that
Yeah,
issue?
there is a disposition to that issue, Your Lordship.
That Florence is the wife?
Yes, there is.
Paragraph?
Yes, paragraph. Paragraph 13 of the supporting affidavit, as read with paragraph 11 of the further affidavit. She holds a position in the Kenya Water Towers Agency, an appointment that was done pursuant to the Gazette notice number 7515 of 2013, for and on behalf of the presidency by Siopan Tuya. Your Lordship, it may go on record that the sixth respondent who initiated or made this appointment is a party in these proceedings, and that the parties.
No, my Lord, that's not factually correct.
I'm not getting you right, and I'm sorry for intervention.
Where are you lost, my Lord?
Here. If I'm looking at the same document as you,
Yes.
the Gazette Notice 7515 was issued on the 7th day of June 2023 by Soipan Tunya,
That's correct.
Cabinet Secretary for Environment, Climate Change and Forestry.
That's correct.
The sixth respondent in this proceedings is who?
He's the president.
Then, where is the next?
I'll get there. I'll get there. Your Lordship, the cabinet under the Constitution is constituted of the president, and the cabinet secretaries appointed there rather, and the deputy president of the Republic of Kenya. That Siopan Tuya is an agent of the presidency. Your Lordship, one of the issues that was before the impeachment was that the deputy president, the petitioner herein, indicated that Kenya is a shareholding country. There are shareholding agreements before you, and that positions either in parastatals or corporations were to be shared in accordance to that share agreement.
My Lord, that is the reason why his client got impeached. That is not anything that is before you for determination. That is the reason he got impeached.
You'll be given an opportunity to respond. Even if you are itching, Mr. Nyamondi, take your call. Your Lordship, it is my client's submissions that Florence Auma Oluoch may have been a beneficiary of that shareholding. Your Lordship, finally, Your Lordship,
Kindly, just
We have-
finally.
Just a minute.
It is extremely unfair and unjust, especially for an advocate to mislead or what we have seen to play to the gallery like evidence. Can we read paragraph 12 of the affidavit? So that he does, no.
Yes.
Let's hear it from him, where he says that the said board is chaired by the president, who has. So can he kindly do it properly so that you don't.
I'm sorry, I'm not.
Excuse me. No, excuse me. No.
Hold on.
Your honors, your leadership and my lords, they will have time, as you said, to respond and say all these things. If he's saying nonsense, they'll stand up and say so. But this constant interruption is intended to derail this hearing. Let them respond when their time comes. Yes.
And
Stop bullying people.
And we abhor the condescending nature of the respondents. Everybody here has been instructed by a client either to speak sense or nonsense. So, that being the case, the condescending attitude is completely objectionable. And everybody should take their seat and use their time with sense. If sense can only come from them, they do it during their time.
Thank you very much. Sir, can I finish what
My
I
lord,
was
may
saying?
I be protected to urge my application and the respondents be granted opportunity to
Let me
respond?
finish what I was saying.
You will have your time.
I know I will have
to
my
respond.
time, but please, this is the application being presented. Let's not have other things.
It has been served upon you.
You will respond.
Just
I'm
permit me to
not-
say one thing. Just one thing.
Your Honor, if I'm allowed to just say something.
Just a minute, Council. Just a minute, Council.
Let applicants finish their case and then people will respond. Because this interjections is just going to affect the conduct of the proceedings. It's very unfair. Let everybody have a chance. Each person has 10 minutes, others have 5 minutes. Let them utilize their time. But these objections in between is unfair and it's affecting the flow.
That's the fact.
Come to court and say that.
My lords, this is what I want to say.
Order. Can we have some order? Can we please have some order? Harvey, you may proceed.
A judge is first an advocate, second an advocate. We're all here advocates. My plea is we conduct these proceedings in an orderly manner. As Professor Gidu Bujai used to remind us when we were in school, to be an advocate, you are a superior mortal. Can we just be slightly superior and deal with this thing in an intelligent way?
Sandagwa, use your remaining time to conclude.
I am most obliged, Lordship. It may be noted that, Your Lordship, that the chair of this board is directly appointed by the President, the six respondents in this case. Your Lordship, may I submit again that the perception out there is that this bench has been constituted for a particular purpose. And that the bench is just a mere conveyor belt, and that the parties herein will not have the chances to have justice of their case being dispensed. Your Lordship, I have annexed a tweet by Senior Counsel Ahmed Nasir, annexed in our affidavit at paragraph 12, and I would wish to read that tweet, Your Lordship. Ahmed Nasir, Your Lordship, is a senior member of this bar, a senior counsel, and Your Lordship, here it goes. The conservatory orders will be discharged by the 3-judge bench, latest by next week, if not by Friday. Even as we approach you, Your Lordship, the perception out there is that this bench is part of the conspiracy.
My Lord, may I object to that? Ahmed Nasir is not the law.
Your Lordship,
He speaks not to the law. Ahmed Nasir has also an affidavit. He is not a witness, my Lord. How does Ahmed Nasir, and we have 64 senior counsel, how does Ahmed Nasir, how can his tweet inform submission before this court?
may I answer that, Your Lordship, to the good professor? that we are speaking about perception. The standard of a bystander, the reasonable man, a fair-minded man in the status and the character of a senior counsel, Ahmed Nasir says, and the president's lawyer says, we cannot receive justice. That is the standard.
My Lord, Ahmed Nasir says that this court will quash the impeachment of Rigathi. No, but the point is, he then speaks in your favor. Pick that line.
Let him respond.
You will not teach me how to submit. You will pick the line that you so wish. For me, I am saying, Your Lordship, that the perception out there is that this bench has been constituted as a conveyor belt. Finally, Your Lordship, this court will remember that on the 16th of October, we moved the court for a mention on the 18th. The court declined to grant that mention and slated our file to be mentioned on the 29th of October. But when they were moved by parties in these proceedings, the court was generous and gracious enough even to sit on a weekend, to sit on a Saturday. Noting that we were before you, you slated our matter for the 29th, and never saw the urgency. Your Lordship, how can a fair bystander be convinced that this court will dispense with substantive justice? How can it be said that this court is impartial? Your Lordship, the question of a spouse being linked to a judge, as indicated by Rules 47, is of paramount importance and something that cannot be ignored. Why didn't the court disclose to us? Why did the court conceal? If the court can conceal such kind of apparent evidence, what else is it capable of concealing? Your Lordship, permit me to indicate that in our affidavit that would wish to expunge paragraph 16 of our affidavit, supporting affidavit, will not rely on it, and paragraph 10 of the same affidavit will not rely on the same. But the standard, Your Lordship, is that of a bystander. Ahmed Nasir spoke, and he has a following of over 1 million on his Twitter handle. That is, the perception has been created to the Kenyans that this bench, 1, is a conveyor belt, 2, it is considered for a particular mission, 3, it's part of the conspiracy. Your Lordship, we urge you to uphold our application and grant the prayers sought. Your Lordship, my learned friend Mr. Macharia will highlight on the authority with the authority in support of my submissions and those of Kibe.
Sorry, just a slight clarification on the expansion. Paragraphs 10 and 16, if I had properly.
Yes, that's correct.
Of the supporting affidavit.
That's correct.
I don't know whether we can do that through oral submissions. You cannot expunge a paragraph from an affidavit as it is evidence before the court, and it has to be considered, it has to be challenged in all ways. Number 2, if you expunge paragraph 16...
Can you cover it in your response, please?
I may, but if you expunge 16, I have a problem with that. There is no application before you. If you expunge paragraph 16 from the affidavit, there is no application as being urged before you. So we need all this clarification. Let's not take things lightly.
Yes, Your Lordship, yes, it is true that the paragraph that I seek to expunge is paragraph 16.
Paragraph 16 of which affidavit? By who?
It is the affidavit of the 22nd
And 16 is
the applicant's affidavit. That is Obuli Namenya.
This is 10, 16 is
My Lord, permit me with
Perhaps, my Lord, again, because we have to be fair to the court, my colleague has to be candid and confirm to the court. The reason is withdrawing that paragraph 16 is because the claim there is factually false. Because you can't just withdraw and leave the world thinking...
We are not even seeing that paragraph 16. Can you read it, the paragraphs we want to withdraw?
and 10 and 16.
Your Lordship, are you having the same application?
Read as paragraph 10, which we want to withdraw, and paragraph 16, so that we can consider if it can be withdrawn.
It's a lie.
In English, just read it.
We give Mr. Devoa, my lords, your leadership, the opportunity to finish his...
Yes. Let him read those paragraphs,
Yes.
so that we can sit down.
No, I agree. I'm just saying, protect him from these tutorials that he's getting from this side.
Order, please. Order. Please read as paragraph 10.
Your Lordship, I wish to say that most respectively, I wish to say no more in respect to the paragraph.
This is a direction from court. Read paragraph 10 and paragraph 16. Read
Paragraph 16 reads,
paragraph 10 first.
may I have some peace, Your Lordship?
No, listen, please, listen.
Who is in conduct?
Listen. Bana Njiru,
Yes, Your Lordship, I'll read.
you have applied to expunge
Yes,
paragraphs 10 and paragraph 16.
Yes, Your Lordship.
Can you read those paragraphs which you intend to expunge?
Your Lordship, paragraph 16 says that...
Paragraph 10.
It's the code.
And Your Lordship, may I take note that these paragraphs have been expunged?
We have not expunged those paragraphs. It is your application.
Expunged them. The petitioners have credible information that Honorable Mrima is a close associate to the proposed Deputy President, one Mr. Kidore Kindiki, and that the said judge failed, refused, or neglected to disclose those facts to the parties at the inception. The basis of the application to expunge that particular paragraph is on the basis that the same has been linked to the affidavit sworn in petition 015. Paragraph 16, that Lady Justice Mugambi is convicted as she should recuse herself, as she was Mr. Kidora Kindiki's LLM student at Moi University.
We have no LLM program at Moi University.
Professor
You will
Jenda,
have your time to submit, sir. And that's why I'm expunging it. That's why I'm expunging this paragraph. That is what my client said. A crucial issue that she failed and or refused to disclose to the parties. My client has learned that she was not an LLM there and that she only took her degree in that university.
We have no objection to anything being expunged, subject to the court observing that if this witness has lied about these two issues, what else has he lied about?
In a ruling, because application has been made and the response is there, but we decline the invitation to expunge those paragraphs. They will remain as part of the record. Dr. Kamuna, we would appreciate if you want to address us in the course of the, as in you are submitting. Is that the position?
Yes, that's right.
Okay, proceed.
My position is that if there is a party,
Are you supporting the motion?
I'm supporting my land friends complaint to everyone to my land friends.
You need to go.
Thank you very much to my senior. My lords, I'll take about 15 minutes. Mercifully, my issues are issues of law. They will not incite any shooting up from my respondents, or should not. My lords, my lords and your ladyship, I have submitted some two cases. The first case is the case of Standard Chartered Financial Services and another versus Manchester Outfitters. I don't know that you have that with you. And the second is a case called Naveen Premjikerai versus Virunga Limited and others. In the case of Standard Chartered Financial Services Limited versus Manchester Outfitters, and this remains, as far as I'm aware, the first case where the Court of Appeal reviewed a judgment, a concluded judgment, set it aside and varied it. And the only question before that court that led it to this decision was the question of bias. I invite my lords and your ladyship to paragraph 1 of the decision, where the court says as follows in trying to frame the seriousness of the issue. And I'm reading from the second line. It is a rare application in which the applicants seek to have the judgment of this court reopened, re-examined, declared nullity, set aside, and the appeal had afresh. I invite you now to go to paragraph 9. We've done back-to-back a photocopying, but if you look at paragraph 9, in the middle is in bold the words Jasbir Singh Rai and two others versus Talukan Singh Rai. And the court is saying what it held. And it says this. During the pendency, my lords and your ladyship, are you there? In the middle of paragraph 9, during the pendency of the applicant's motion and the respondent's preliminary objection, this court, in a 5-judge bench decision in Jasbir, and they give the whole case there, held inter alia, that it was only mandated to hear and determine appeals from the High Court and could not revisit its own previously concluded decision, nor did it have powers to reopen and rehear a finally concluded matter. In light of the decision in the Rai case, it was deemed appropriate that since this matter raises similar issues, it be similarly heard by a 5-judge bench hence the unusual composition of this bench. They are merely underlining the importance of the matter the court was dealing with. Permit me now, Your Ladyship and my lords, to invite you to paragraph 63, where the question that vexes you this afternoon is dealt with. At paragraph 63, they deal with a case which we've also supplied the court and my friends with. This is a well-known case of Senator Agostino Pinochet. But at paragraph 63, this is what they say. Bias, whether it is perceived or actual, undermines the public confidence in a judicial officer's ability to dispense justice. They then cite a caption by Lord Joff in R versus Gao. Justice must be rooted in confidence, and confidence is destroyed when right-minded people, the right-minded people that Mr. Ndegwa was talking about, go away thinking the judge was biased. At paragraph 65, the case of Webb versus Queen, in considering the merits of the test to be applied in a case where a juror is alleged to be biased, it is important to keep in mind that the appearance as well as the fact of impartiality has been done. And this is what they say at paragraph 66. And this, my lords and your ladyship, is what I would be beseeching this court to find favor with when you retire to do your ruling. The rule against bias is as important an element of the right to a fair trial. This rule, and now this is our own 5 judgment saying this in the Court of Appeal, this rule is to be very strictly applied so that even the appearance of bias is done away with, the appearance alone. This is because it aids in public confidence in the fairness and impartiality of the judicial system. In view of the jurisprudential importance and uniqueness of this application, they then cite a case called R versus Sussex. Justice should not only be done, but should manifestly and undoubtedly be seen to be done. I will leave for you to read paragraph 67, which I also recommend to you. And then paragraph 71, another English case cited. First, actual bias will of course always disqualify a person from sitting in judgment. Even in the absence of actual bias, however, the importance of public confidence in the administration of justice is such that even the appearance of bias will disqualify. And they say emphasis added. And I would also invite you to look in the fullness of time to paragraph 73 and 74. Paragraph 81, they cite the case cited earlier, I think I mentioned it. This is the case of Agostino Pinochet. It actually begins at paragraph 80. There's a long passage, I'll not read it on account of time. But at paragraph 81, they cite the basis for the reason the 2 applicants before you have moved you. It's the Latin phrase, nemo debet esse judex in propria causa. No man is to be a judge in his own cause. Then at paragraph 82, Lord Hope in the same decision. Indeed, it may be said of all the various tests which I have mentioned, including the maxim that no one may be a judge in his own cause, that they are all founded upon the same broad principle. Where a judge is performing a judicial duty, he must not only bring to the discharge of that duty an unbiased and impartial mind, he must also be seen to be impartial. Having considered all those, the court, and in that case what the issue was that the late Justice Laka had represented one of the parties previously, not in this matter, but previously. But at paragraph 86, they give a summary of what I've told you, and then go to paragraph 88, and then this is how the court finally resolves the matter. And I would also recommend to you paragraph 90. Let me read paragraph 90 before going to the conclusion. The mere probability or appearance of bias was enough to breach the cardinal rule of fair trial in the administration of justice. Having raised the issue of bias arising from the same circumstances in the hearing of an interlocutory application by the same judge in a matter involving the same parties, we do not understand why the applicant's counsel failed to raise the issue during the civil appeal. That omission notwithstanding, the seriousness of the bias, of the issue of bias, cannot be underrated. As observed in the Benjo case, bias is one of the grounds that would justify review of a previous decision of the Court of Appeal. As I said, this was the first time it's ever happened in the history of the Court of Appeal, and as far as I'm aware, the only time it has happened. So paragraph 95, this is what the court says. Accordingly, we allow this application, declare that there was a failure of justice in the judgment dated 4th October 2002, and we accordingly invoke the court's residual jurisdiction to correct that injustice by reviewing the judgment and setting it aside with all the consequential orders. Now, my learned friend, Mr. Kibe, has referred you to a passage that my good and learned friends for the respondents insisted must be read. And this is a question of the attendance of a wedding where gifts are shared by a judge who, the gifts are received by a judge by a party who is before this court. We are before this court because the first petitioner was impeached in the Senate. The Speaker of that Senate is a party in this case. In the document presented by Mr. Kibe, the Speaker describes the judge, and there's nothing wrong with having friends, as I should say. I need to say this. He says, my long-time friend. This is what he says. Now, we found a decision, and I've shared it with you. This is the case of Naveen, where on all fours, a similar situation occurred. And I invite the court now to look at paragraph 70, and allow me to read this, because I won't be reading anything else after I read this. This is what the court, this, as I said, is Naveen Kerai versus Virunga Limited and others. I begin to read. I say paragraph 70, please forgive the coloration of the authority. And this is a 2022 decision. So both the Standard Chartered case and the case before you were determined under the current constitution. And as I'll be demonstrating here, they also took into account the Judicial Code of Conduct. I'm reading from paragraph 70. In this matter, the third respondent declined to recuse himself. This was a matter of an arbitrator appointed under Article 159, declined to recuse himself on the basis that the relationship between him and the counsel for the first and second respondents was a professional one. This court, however, takes judicial notice of the fact that in the Kenyan context, invitations of colleagues to weddings is extended to those that one considers close, and such invites are not extended to all and sundry. Had that been the case, then the third respondent could have as well extended the invite to the counsel for the applicant, who is an advocate just like him. Given the circumstances, this court arrives at the inevitable conclusion that apart from being a professional colleague, the third respondent and counsel for the first and second respondents are friends. And that is the perception that any reasonable, objective, informed member of society would reach based on the circumstances of this case. I continue, paragraph 71. As counsel for the applicant stated, it is common knowledge that there is the custom for invited guests to give gifts at a wedding, exactly as happened in the case Mr. Kibe showed you. In this case, apart from the third respondent and the counsel for the first and second respondents, the applicants and their counsel will never know if the counsel for the first and second respondents was a gift-bearing guest at the traditional wedding or not. In this case, we know, because the photograph depicts a gift. It, however, boils down to the failure by the third respondent to disclose to the applicants and their counsel that he intended to invite the counsel for the first and second respondents to his traditional wedding and seek their views on the same. I need to emphasize that the real issue here is not that a wedding was attended. It is that that issue was not disclosed prior to the hearing and dismissal of an application in this matter and the continued conduct of these proceedings. I continue. Bearing in mind the final nature of arbitral awards, which can only be set aside upon a litigant satisfying the conditions stipulated under Section 35 of the Arbitration Act, the need for disclosure becomes even more critical. Paragraph 72. In S versus Roberts, the court stated that the apprehension be that of the reasonable person in the position of the litigant, and that is based on reasonable grounds. I continue at paragraph 73. The counsel for the first and second respondents has stated that since he and the third respondent are arbitrators who have served at the Chartered Institute of Arbitrators, Kenya branch, as chairman and vice chairman of the institute respectively, during the same tenure, they were bound to interact or have interacted in the Chartered Institute of Arbitrators events, trainings, board meetings, and members' welfare gatherings while discharging their professional mandate. I do agree that the above events are professional in nature. However, Weddings are personal events where families, friends, and close colleagues are invited. The lack of disclosure by the third respondent that he had invited the council for the first and second respondents to his traditional wedding is one that leads to the perception of bias. Due to the failure to so disclose on the part of the third respondent, it has led to an erosion of the confidence that applicants have that he will be neutral when it comes to the hearing and determination of the arbitral proceedings before him involving the parties hearing. In conclusion, this court holds that there was lack of transparency on the part of the third respondent, and he should have done the honorable thing when he was requested through an application to challenge to recuse himself from the arbitral proceedings in nature. This court finds that the justifiable doubts have risen as the third respondent's impartiality and independence, and the same have been proved by the applicants. This is a decision, and the only one we could find that addresses on all fours the issue that confronts this court. I ask this court to find favor with this decision, to recuse itself, and I do so with tremendous respect. It's just that the nature of the matter, nature of the issues, and the perception as such as are captured in that decision. Recusal would be the only thing that would do justice to not only the applicant before you, but to the court itself. Thank you for the privilege of your attention, for your time. Unless you have any questions, I'll rest at that point. I said it, soft copy, you have.
My Lord, it's my humble submission that your Lordship must exercise flexibility. The usual case law making a recusal is inapplicable in this case. As a matter of fact, I will say to you very respectfully, if there are parties, and if there are, who do not want, who do not wish to see you hear this matter, please walk out. You are not the only judges in the country. Let another panel of judges be appointed to hear this matter. My Lord, if I may say so very respectfully, to refer to my own history. When you reach my age, you keep on looking at your history. I remember there were one or two expatriate judges, colonial judges. The moment you say to him, to him, to your Lordship, I would like you not to hear this matter. I want you to recuse yourself. His response was, okay, Hanima, if you don't want me to hear this case, let another judge hear it. That is the attitude you should take. Those of us who have had the advantage of receiving higher education know when you're giving introduction to philosophy, you are taught that perception, the first course you take is perception and reality. Perception and reality. When you're studying philosophy, perception is a very important concept when it becomes the arena of politics. Reality may be completely different. And indeed, I believe it is different in the case before your Lordships. I appear before you very often. I've never entertained any idea about your standing relation to justice. But the perception now that has been painted by my able, learned friends, clients, Mr. Ndegwandiru, Mr. Kibe, and Mr. Natalia, that there is a sizable portion of the Kenyan population which will not be happy to hear you sit and listen to this case at all. And may I remind your Lordship very respectfully, impeachment is politics of the country. There is no way you can move away from that at all. I would respectfully refer you to a book I've taken the trouble to read.
Your Honor, sorry for the interruption. We are muted again. Perhaps you could be unmuted so that we follow the proceedings.
I wonder why it has happened in respect of Hamid. Can I speak now? Can I speak?
Yes.
Yeah.
Yes. Your Honor, there is a book here, Politics of Presidential Impeachment. Politics of Presidential Impeachment. I've taken the trouble during the weekend to read this book. Impeachment is politics of the country. There's no way you can remove it from the politics of the country. And that's why I'm saying to you very respectfully that as you have been told, there are some people who feel very strongly that it should not be this. Get out. Let them get other judges to hear the case. You have no vested interest in the matter. There's no reason for you to remain in the case when other people do not want you to hear the case at all. May I remind you, my lords, when you are hearing impeachment cases, advocates will be able to think broadly and bring to your notice the culture of the people that you are serving. There is a little song that is sung by a little girl in Kenya. To those of us who listen to Kenyan radio may have heard of it. She says in Kiswahili, Kenya ni nchi ya watu wa akili kidogo. She sings very beautifully. Kenya ni nchi ya watu kidogo. Na wanataka kitu kidogo ndio wafanye kitu. Majority of our people are not the people who are in this country before. Majority of our people are people who have not had the advantage of receiving the education, the training that the judges and the advocates, the members who are in this room. And as one of my learned friends very aptly pointed out, majority of the people believe that the case before you has been engineered by the politics of the country. And if some of them believe that your lordships cannot hear them, again, I say to you very, very respectfully, you stand to lose nothing. You better leave the case, let other people hear the case, and you will continue to maintain the name. My Lord, to go back to the politics of the impeachment, this matter was passed at the National Assembly. The National Assembly very overwhelmingly stated that the deputy president had been engaged. It was then referred to the Senate, and the Senate again stated very overwhelmingly that the deputy president was guilty and convicted My Lord, the stories that one hears in the streets of Nairobi, the stories that one hears elsewhere, you cannot afford. That may be so or may not be so, but it doesn't matter. They have made the point that members of parliament received bribes and they handed down a decision which majority of people believe that it was a corrupt decision. You cannot afford to ignore that. Now, when you go to the Senate, you are told the same thing, that members of the Senate received money in what is called white partial or something of the sort, white partial. They received money from known people. Again, you cannot afford to ignore that at all. Now, when they come to the judiciary, they expect the best. They expect people who have got integrity. They expect people who can hear them and whom they cannot suspect at all. But if then they are suspecting some people, whether truthfully, whether honestly or not, it is my humble submission, the natural thing as a judge, if I was sitting where the Lordship are sitting. When we had a program recently during the time when we for President and the matter went to the Supreme Court, it is again the judiciary that saved the country. Now, if you find people now are questioning the very institution of the judiciary, just say thank you, I'm moving out. That does not necessarily mean that there is something wrong with you at all. And as I said, my Lord, I've spent many years appearing before your Lordship, Mr. Justice Okola in Mombasa. At no time did anybody ever open his mouth and say to me that, Kamenwa, this Justice Okola is this, is this, is this, is this. Nobody ever did it. My Lord, Mr. Justice Moreno, I've had the privilege of appearing before you in many cases. There are cases where you have given me rulings. There are cases where you have not given me orders at all. But at no stage did I ever entertain an idea that there is something wrong with Justice Moreno. We have confidence in all of you. But now, this confidence of perception. There are some people who feel very strongly that Justice Okola should be out. Justice Moreno should be out. And let the judge, may I say, I'm leaving you, I'm not discriminating against you. I'm one who has fought for rights of women. And I kept on shouting very loudly that we want women judges. I have not had the fortune of appearing before you very often.
Actually, you have on a couple of times.
My memory is letting me down. But my Lord, may I say, I have had the opportunity of appearing before you. And may I say this much, my Lord, if you go and check the Judicial Service Commission records, you will not find a single letter from John Kaminwa complaining against any judge. I have never done such a thing at all. It's because I've got confidence in our judges. I've got confidence in our magistrates that they deliver justice. But I'm just saying you, my Lord and my Lady, if at this time we have some people who feel very strongly in the camp because they may not get justice before you at all, please walk out. Don't continue to hear the truth. And indeed, the people who are saying that your lordships or my lady do not hear this case, when they are speaking, you cannot really criticize them. They have got some valid complaints. My Lord, United States of America, which I had the opportunity and the privilege of getting and studying their jurisprudence, they gave me additional legal education. United States of America, which has an impeachment provisions like Kenya, for 200 years, there is no precedent or deputy president who has been impeached and the impeachment has succeeded. None at all. None at all. Kenya, a young country which got the first constitution involving impeachment provisions, came into operation in 2010, and in 2024, we are now being told the deputy president has been impeached successfully, has been found guilty. Is it unreasonable to suspect there is something wrong? Is it unreasonable to suspect that someone is doing something wrong? Gachagua may be an actor, may not be properly educated, but he's a deputy president of the Republic of Kenya. Why should he be the first one within such a short time to be impeached in the country? Can't you suspect there is something wrong? That you are not doing some things properly? That America, which has had impeachment provisions for 200 years, has never successfully convicted someone for impeachment as for a politician.
Thank you, Dr. Kabinwa. Thank you very much.
May I say thank you? May I say with your respect, I would appreciate if you would uphold my submission. Thank you.
Just 2 minutes, my lords. In considering this application for recusal, I agree that you bear in mind the following. One, your brother, Mr. Justice Chachamwita, your brother, Mr. Justice Mugambi, your brother, Mr. Justice Mwongo, sitting separately, each one of them was persuaded that the petitions and the notices of motion asking for conservatory orders raised weighty constitutional issues. That is why this bench was constituted. Those weighty issues await full arguments by both sides for the court to resolve. Number two, the weighty issues are around the petitioner applicant, the deputy president, challenging and seeking to have the impeachment quashed. In the interest of time, I will not restate those weighty issues. They are in the record before, but they are there. Challenging the impeachment and seeking to have the impeachment quashed. For the sake of this country, today and going forward, those are issues that must be heard and adjudicated by a bench that has no issues of bias, apparent or real, being raised against. So for that reason alone, please accede to recusing yourselves so that another bench will be set up to adjudicate those issues. So I thank you.
Very briefly, Your Lordship. My name is Gachagua. I would like to talk about just three aspects on the subject of